Derek Calloway spent 14 months and $92,000 constructing a private road across land he owned free and clear. The Jefferson County records confirmed the property boundary. The property survey was filed with the recorder's office. His property rights were absolute, and yet the HOA decided those rights didn't matter. The private road connected Derek's 12-acre parcel directly to the county highway. It bypassed the Pinecrest Estates entrance entirely. The zoning ordinance permitted the construction. Every Jefferson County permit had been approved. There was no legal ambiguity. The private road belonged to Derek alone. Within a week of completion, Derek received a compliance notice from the HOA board president, Sandra Pembroke. The notice demanded he submit to an architectural control review and cease all use of the private road immediately. Derek read the document twice. It cited no specific bylaw violation. Derek reviewed his CC&Rs and deed restriction documents line by line. His parcel had been annexed into Pinecrest Estates years before purchase. But the CC&Rs contained no clause granting the HOA authority over individually owned parcels or privately constructed roads. The HOA overreach was undeniable from the start. He responded to the compliance notice via certified mail. The envelope contained a copy of his property survey, the Jefferson County approved permits, and a letter from his real estate attorney confirming the HOA had no jurisdiction. Derek kept the certified mail receipt as documentation. Sandra Pembroke ignored the certified mail response entirely. She convened an emergency board meeting. The HOA meeting minutes later confirmed a unanimous vote declaring Derek's private road a community safety hazard. No inspection had been conducted. No evidence was presented. Board misconduct was already on record. 3 days later, Derek found 2 large signs posted at the entrance to his private road. One read, "No trespassing, HOA property." The other declared, "Unauthorized access prohibited." The unauthorized signage had been placed on his land, a direct trespass on private property. Derek documented the unauthorized signage immediately. He photographed each sign with GPS-stamped images, recorded video with a visible property boundary marker in frame, and emailed everything to his attorney. His lawyer confirmed the trespass was actionable and advised escalating to a demand letter. The next morning, Derek received a notice of HOA fines. The amount, $1,500 for unauthorized road construction. The cited bylaw violation referenced architectural modifications to common areas, not privately owned land. The HOA fines were baseless. His attorney reviewed the bylaw violation claim and confirmed it had no legal basis. The cited section governed common area landscaping, not private road construction. The board misconduct was compounding. Derek's attorney began preparing a formal response and a comprehensive damage assessment. Derek refused to pay the HOA fines. His attorney sent a formal demand letter via certified mail asserting Derek's property rights and warning the board of significant liability exposure. The demand letter stated that continued trespass and fraudulent fines would result in civil litigation. The HOA doubled the fines to $3,000. They added a second charge, failure to submit an architectural control dispute form. Derek had never been required to submit one. The private road sat on his deeded property, entirely outside the HOA's jurisdiction. The HOA overreach escalated. Sandra Pembroke distributed a letter to every homeowner in Pinecrest Estates, accusing Derek of building an illegal road that endangered property values. Derek's attorney flagged the letter as potential tortious interference, designed to damage Derek's property rights and discourage prospective buyers. The litigation cost was climbing for everyone. The chronic stress consumed Derek. His blood pressure surged. A physician visit documented readings consistent with stress-induced hypertension directly linked to the HOA conflict. The doctor ordered follow-up monitoring and noted the chronic stress response in Derek's medical file. Derek was referred for a psychological evaluation. The evaluator documented anxiety, insomnia, and diminished concentration, all stemming from the HOA's harassment campaign. The psychological evaluation report specifically cited the baseless HOA fines, the trespass, and the public defamation as contributing factors. Medical expenses mounted rapidly to specialist consultations, prescription medication, a follow-up psychological evaluation. Total out-of-pocket medical expenses exceeded $4,000 within 60 days. Derek filed every receipt with his attorney for the medical damages claim. The HOA escalated further. A lien threat arrived for unpaid HOA fines, now totaling $4,500. Derek's attorney filed an immediate objection, citing a due process violation. The board had never granted Derek a hearing before imposing any penalty. Due process had been completely ignored. Derek requested a formal due process hearing in writing. The HOA denied it, claiming the emergency board vote superseded standard hearing requirements. His attorney called the denial a textbook due process violation and added it to the growing civil litigation file. The comprehensive damage assessment now exceeded $47,000. Construction delays, attorney retainers, medical expenses, lost wages, and emotional distress. Derek's attorney documented every dollar. Derek filed a formal complaint with Jefferson County, documenting the unauthorized signage, the fraudulent HOA fines, the trespass, and the board's refusal to follow due process. The Jefferson County Records Division opened an investigation within 72 hours and requested all HOA meeting minutes. Derek's attorney filed for a declaratory judgment in county court. The petition asked the judge to confirm the HOA had no authority over Derek's private road. Simultaneously, the attorney requested injunctive relief to prohibit any further trespass, unauthorized signage, or lien activity against Derek's property. The HOA's insurance carrier was formally notified. An insurance claim investigation was initiated to assess whether the board's actions fell within their liability coverage. The carrier assigned an adjuster who requested copies of every demand letter, every fine notice, and all board meeting minutes. The adjuster's preliminary findings devastated the board's position. The report concluded the board had acted outside its governing documents, potentially voiding liability coverage entirely. A coverage dispute between the HOA and its insurer was now formally underway, compounding the settlement risk. Derek's attorney expanded the civil litigation. Tortious interference claim was added, alleging the HOA's public campaign labeling the private road illegal had sabotaged a pending land lease negotiation worth $65,000. The property rights violation now carried measurable financial consequences. A court-ordered financial audit of the HOA's books uncovered something the board had hidden. Over $11,000 in homeowner assessments had been redirected to fund the signage campaign and legal costs against Derek without a membership vote. The financial audit documented every misappropriated dollar. The HOA's insurer completed its policy review. The conclusion was catastrophic for the board. Arisa Fouchon's rights letter warned that intentional board misconduct, including unauthorized signage and fraudulent HOA fines, might exclude the entire matter from liability coverage. The settlement risk shifted entirely to the individual board members. Derek's attorney filed a supplemental civil litigation brief incorporating the financial audit findings and the policy review denial. The filing requested punitive damages on top of compensatory relief. The argument was clear. The board's misconduct was not negligent. It was deliberate, sustained, and financially motivated. The medical damages assessment was formally submitted to the court. Derek's physician and the psychological evaluation expert both provided sworn affidavits connecting his stress-induced hypertension and chronic stress symptoms directly to the HOA's sustained harassment. The medical damages claim exceeded $19,000. The Jefferson County investigation concluded. Officials confirmed Derek's private road was built entirely within his property boundary on land verified by the property survey, with every permit approved under the applicable zoning ordinance. The Jefferson County records showed 0 violations. The unauthorized signage, however, constituted a code enforcement issue against the HOA. The sheriff's office dispatched deputies to Derek's private road. Derek recorded the entire encounter on his phone. The sheriff examined the Jefferson County records and the property survey. He confirmed the signs constituted trespass on private property. On camera, the sheriff ordered both signs removed. They came down in minutes. Derek uploaded the sheriff's video to the Pinecrest Estates social media page. Homeowners watched a uniformed officer physically remove the HOA's unauthorized signage from Derek's private road. The board's credibility disintegrated overnight. Residents who had trusted Sandra Pembroke's claims demanded answers. The HOA's attorney initiated settlement negotiations with Derek's legal team. For the first time, the board acknowledged its liability exposure. The initial settlement offer was $12,000. Derek's attorney rejected it immediately, calling it an insult given the documented damage assessment and the pending punitive damages motion. The court granted Derek's declaratory judgment. The judge ruled the HOA held no jurisdiction over the private road and voided every HOA fine imposed. The ruling declared the signage placement an act of trespass and confirmed Derek's property rights had been violated, repeatedly and intentionally. The judge's written opinion cited the HOA's failure to follow due process, the absence of any legitimate bylaw violation, and the board's deliberate disregard for Derek's certified mail responses and demand letter. The opinion described the board misconduct as willful, unreasonable, and conducted without lawful authority. Injunctive relief was granted immediately. The court permanently prohibited the HOA from placing signs, barriers, or any obstruction on Derek's private road. Any future trespass would trigger contempt of court penalties starting at $5,000 per incident. The injunctive relief was absolute and enforceable. The board's liability exposure reached catastrophic levels. With the declaratory judgment on record, the coverage dispute unresolved, and the financial audit exposing misuse of homeowner funds, each board member now faced personal financial responsibility. The insurance claim offered no protection. The litigation cost had become theirs alone. Settlement negotiation resumed under extreme pressure. Derek's attorney presented a final demand: full reimbursement of all legal fees, every dollar of medical expenses, construction delay damages, and compensation for emotional distress. The total demand, including the request for punitive damages, exceeded $185,000. The board settled for $162,000. The settlement included reversal of all HOA fines, removal of every lien threat, a written admission that the HOA had no authority over the private road, and a formal retraction letter mailed to every homeowner in Pinecrest Estates. Sandra Pembroke resigned as board president within the week. 2 other directors followed. A recall election replaced the remaining members with homeowners who had publicly supported Derek. The new board ordered its own financial audit and pledged to end the era of HOA overreach. Derek's private road remained exactly where he built it, on his land, approved by Jefferson County, confirmed by the court, defended by the sheriff on camera. Every certified mail receipt, every property survey page, every demand letter had mattered. The HOA learned that property rights carry consequences, and Derek made sure they paid every dollar they owed.